The Common Law by Oliver Wendell Holmes. Preface. This book is written in pursuance of a plan which I have long had in mind. I had taken a first step in publishing a number of articles in the American Law Review, but I should hardly have attempted the task of writing a connected treatise at the present time had it not been for the invitation to deliver a course of lectures at the Lowell Institute in Boston. That invitation encouraged me to do what was in my power to accomplish my wish. The necessity of preparing for the lectures made it easier to go farther, and to prepare for printing, and accordingly I did so. I have made such use as I thought fit of my articles in the Law Review, but much of what has been taken from that source has been rearranged, rewritten, and enlarged, and the greater part of the work is new. The lectures, as actually delivered, were a good deal simplified, and were 12 in number. The 12th, however, was a summary of the foregoing 11, and has been omitted, as not necessary for a reader with the book before him. The limits of such an undertaking as the present must necessarily be more or less arbitrary. Those to which I have confined myself have been fixed in part by the limits of the course for which the lectures were written. I have therefore not attempted to deal with equity, and have even excluded those subjects, like bills and notes, or partnership, which would naturally require an isolated treatment, and which do not promise to throw light on general theory. If, within the bounds which I have set myself, any one should feel inclined to reproach me for a want of greater detail, I can only quote the words of Leclerc, "Nous faisons une théorie et non un spécilège." O. W. Holmes, Jr., Boston, February 8, 1881. Lecture 1. Early Forms of Liability. The object of this book is to present a general view of the common law. To accomplish the task, other tools are needed besides logic. It is something to show that the consistency of a system requires a particular result, but it is not all. The life of the law has not been logic. It has been experience. The felt necessities of the time, the prevalent moral and political theories, intuitions of public policy.
Sample complete. Ready to continue?